Chapter 8 of Changes by Death, Marriage, Bankruptcy, or Insolvency. The personal claim founded upon an obligation survives the death of the obligor, and therefore his executors are bound though not named in the bond. So upon the death of the obligee, his interest vests in his personal representatives, though not included in the terms of it, for the executors and administrators of every person are implied in himself. A bond given to a single woman does not upon marriage vest absolutely in the husband, but being a mere chosen action, must first be reduced into possession, and therefore he cannot sue alone upon it, but his wife must be joined. If the husband neglect during his lifetime to reduce it into possession, his wife, and not his personal representatives, will be entitled to it. If the bond be given to husband and wife, both may join in the action, in which case, if the husband die after judgment, it will survive to the wife, or the husband may disagree to his wife's right to the bond, and sue alone upon it, but if he die without having put the bond in suit, his wife will be entitled to it by survivorship. But it seems that in such case, if she should sue as his executrix, it would amount to a waiver of her right to the bond. So if the bond be given to husband and wife administratrix, the husband may declare upon it as a bond to himself. If a bond be given to a woman during coverture, both husband and wife may join in the action, or the husband may sue alone. On the death of the husband the bond will survive to the wife, and on the death of the wife the husband must sue as her administrator. The marriage of the obligor and obligee will operate as a release of the bond. So if there be two obligees, and the obligor marry one of them, the debt is extinguished. But after a divorce of incolor matrimony the obligation would revive, and in general equity will support the bond as an agreement, though void in law. The general principle of law, that the marriage of a creditor and debtor extinguishes the debt, has received some modification in favor of bonds given before marriage for the purpose of making a provision in the event of the husband's death. In an early case, where the husband before marriage executed a bond to his intended wife, conditioned to be void if she survived him, and he left her a sum of money, two of the judges were of opinion that the debt was only suspended, as it was a contingency that could not by any possibility happen during the marriage. But Holt, C.J. considered that a bond debt was a present debt, and the condition was not precedent, but subsequent, which made it a present duty, and consequently it was released by the marriage. In a later case, however, this decision was fully examined, and the court having expressed great dissatisfaction at the doctrine laid down by Holt, C.J., decided that a bond given by the obligor to the obligee before marriage, conditioned for the payment of money after the obligor's death, and intended for the obligee's benefit if she should survive him, is not released by the marriage, and that if the marriage be pleaded in bar to an action on the bond, the plaintiff may reply, stating the purposes for which the bond was given. It has been before observed, that upon a breach of the condition, the penalty of the bond becomes a debt in law. If therefore the bond be forfeited at the time of the bankruptcy of the obligor, the sum claimed must be proved under the commission, or the certificate will be a bar to any future proceedings. And the law is the same whether the bond be for the payment of money or for the performance or forbearance of any act. But where there is not an existing debt, or if there be continuing damage, which cannot be ascertained at the time of the bankruptcy, the certificate will be no bar to an action on the bond. The late Bankrupt Act has however enabled a creditor to apply to the commissioners to set a value on any debt payable on a contingency, and to admit proof of the amount ascertained. And annuity, bottomry, and respondentia bonds are expressly made provable under the commission, and therefore in these cases the certificate would be a bar. Sureties and bail for the bankrupt are also enabled to prove their demand, if they have actually paid the debt of the principal. But this provision does not extend to the bankruptcy of a co-surety, and, therefore, where the principal and four sureties were jointly and severally bound for the payment of money and interest, and one of the sureties became bankrupt and obtained his certificate, and at the time of his bankruptcy the bond was forfeited, it was held, that as the bond could not have been proved under the commission, the certificate was no bar to an action for contribution against the surety who had been bankrupt. The Insolvent Act directs a prisoner complying with the provisions of that Act to be discharged as to the several debts and sums of money due or claimed to be due at the time of filing his petition to the several persons named in his schedule as creditors. What is therefore above stated with respect to the bond being an actual debt, applies as well to insolvency as to bankruptcy. Where a bond to replace stock at a certain day, and in the meantime pay the dividends, became forfeited by non-payment of the dividends, but the arrears were afterwards paid, and the obligor having become insolvent, petitioned for his discharge before the time for replacing the stock had arrived, the court held, that the bond having been once forfeited, the penalty became a debt, from which the insolvent was entitled to be relieved. And to an action against husband and wife on a bond given by the wife before marriage, a discharge of the husband from that debt under the Insolvent Act would be a good plea.